Hi, everybody. I'm Lissy Medvedow, Executive Director of the Rappaport Center for Law and Public Policy, along with our Faculty Director, Tam Handstrom, and our Administrative Assistant, Abby Chingo. Welcome to today's recorded program, Facial Recognition, Exploring Privacy, Profiling, and Public Safety. As many of us learned on Monday at Kimberly Atkins Stohr's community address, facial recognition is being used virtually, all puns intended, everywhere. The technology is somewhat awe-inspiring and rather terrifying. Today, we're going to delve into the myriad ways facial recognition is being used and can be used, and we'll hear about whether those myriad ways benefit us or harm us. Before I introduce our fabulous moderator, the Rappaport Center's 2024 Senior Fellow, Kim Stohr, I want to share one incredible use of facial recognition that I recently learned from a student and then read about in the New York Times. Here goes. If you are a lawyer at any of the many firms that have sued MSG Entertainment, the company that owns Madison Square Garden, Radio City Music Hall, and the Beacon Theater in New York, you are barred from entering any of those three buildings. Your face is detected on facial recognition systems that they use, and the security guards literally stop you at the entrance. Here's the beginning of the New York Times article that was published in December of 2022. Over Thanksgiving weekend, Kelly Conlon, 44, a personal injury lawyer from Bergen County, New Jersey, was chaperoning her 9-year-old daughter's Girl Scout troop on a trip to Manhattan to see the Christmas Spectacular at Radio City Music Hall. And now I paraphrase. Security guards pulled Conlon over and said, "You are Kelly Conlon, you are a lawyer, and you are a lawyer at X firm, and you are not permitted in the building." And she's not alone. Lawyers at those firms have been stopped from going to Knicks games, Rangers games, and in one notable event, a Mariah Carey concert. The company apparently banned not only the lawyers who directly represent people suing MSG Entertainment, but all lawyers at their firms. And yes, there's a lawsuit that's been filed against the company in U.S. District Court for the Southern District of New York, alleging violations of New York City's biometric identifier information law, as well as New York civil rights laws. Just this past January of 2024, MSG's motion to dismiss was denied in part. So thinking about that, now let me introduce Kim Stohr. Kim is a lawyer who became a full-time journalist now at the Boston Globe, where she is a senior opinion writer and columnist. She's also an MSNBC contributor, co-host of the podcast Sisters in Law, and guest host frequently on WBUR's On Point. She previously worked at the Boston Herald and as the Supreme Court reporter for Massachusetts Lawyers Weekly, and she's appeared as a political commentator on numerous networks, including CNN, NBC, PBS, Fox News, NPR, and more. Before becoming a full-time journalist, she was an actual lawyer at a small firm practicing litigation and appellate work. She's a Michigan native, a graduate of Wayne State University, the U School of Law, the U College of Communication, and Columbia's Graduate School of Journalism. But before we welcome him, as I always do, I must tell you about the next Rappaport Center program. A week from today, we're holding a program addressing the difficult subject of domestic violence, looking at past, present, pending, and potential laws and policies. We have panelists who are experts in the field of domestic violence, custody law, family law, and a law clerk in the probate and family court who was a 2021 Rappaport Fellow and is herself a domestic violence survivor. We hope you'll join us next week in this room at this time with lunch provided, of course. There'll be burritos from Blue Ribbon Barbecue, just so you know. And with that, please welcome Kimberly.
Thank you to everyone, and thank you, Lizzie, for that very generous introduction. And it is my honor to get to introduce this very esteemed panel. Oops. Thank you. I will try that again. Thank you, Lizzie. And it is my honor to introduce this very esteemed panel to discuss today's very important topic, facial recognition technology and the important legal and criminal justice implications of it. I will give brief introductions because all of them are just so esteemed. It would take all the time of today's program. But we are joined by Norwood, Massachusetts Police Chief William G. Brooks III. And Chief Brooks has been a police officer for over 45 years. He was also a member of the Supreme Judicial Court Study Committee on Eyewitness Identification and is a member of the SJC Standing Committee. He also served on a committee at the National Academy of Science and presents nationally on behalf of the Innocence Project. We are also joined remotely by Kade Crockford, who is the director of the Technology for Liberty program at the ACLU of Massachusetts. This program aims to use unprecedented access to information and communications technology to protect and enrich open society and individual rights by implementing basic reforms. And in this role, Kade recently led the ACLU of Massachusetts Press Pause on Face Surveillance campaign, which we will discuss more today. And both Kade and Chief Brooks were members of the Special Commission on Government Use of Facial Recognition Technology here in the Commonwealth. So we'll be drawing on that, and we will be discussing that report a lot today. And last but certainly not least, we are joined by former Supreme Court We're joined by former Supreme Judicial Court Associate Justice Elspeth Cypher. She served on the state's highest court from 2000 until just this past December. Congratulations. And she's formerly Assistant District Attorney in Bristol County and later became in that office as Chief of the Appellate Division and argued many cases before the SJC before she was appointed to it. She's also worked in private practice and is now a Huber Distinguished Visiting Professor here at BC Law. So first, I want to give each of our panelists just a little bit of time to make some remarks and highlight some of the things that they think are most important in this discussion. And then I will begin asking them some questions and hoping that we can engage each other in a little bit of dialogue. And then we will welcome questions at the end of the program. So since Kade is joining us remotely, I want to give her the first shot at making some remarks.
Well, okay. Hi, everybody. Good almost afternoon. Coming at you live from Vermont. Apologies that I can't be there in person, but I had a previously scheduled vacation for this week. So after this, I'll be trying to catch some snow. Like Kimberly said, I work at the ACLU of Massachusetts on a range of technology and civil rights issues. And a few years ago, 5 years ago, actually, in 2019, our office in Massachusetts launched a campaign called Press Pause on Face Surveillance. The goal of that campaign was to really do three things: to work with municipalities and local government officials across the state to pass municipal prohibitions on government use of facial recognition technology, to educate the public and lawmakers about the civil rights and civil liberties dangers that this technology poses, particularly in the hands of government, particularly when there are no regulations on police or other government use of facial recognition, which was the case when we launched our campaign in 2019. There were no laws at all in Massachusetts and in most states. And then the third goal was to pass statewide rules to govern police use of facial recognition technology in particular. And in the 5 intervening years, we've been pretty successful. We've passed 8 municipal bans on government use of facial recognition, including in Massachusetts' 4 largest cities, Boston, Cambridge, Worcester, and Springfield. And we worked with state lawmakers to pass some initial reforms governing police use of facial recognition technology statewide. Those reforms have some gaps in them, which is something that the legislature also believed was a problem that needed to be addressed, which is why they created in the 2020 police reform legislation not only some initial regulations on police use, but also a commission to study whether there ought to be further reforms. That commission was chaired by the House and Senate chairs of the Joint Judiciary Committee, Senator Jamie Eldridge and Representative Mike Day. And it was staffed by a number of experts from various fields, including a guy named Dr. Eric Learned Miller, who's a computer science professor at UMass Amherst, and in fact is a developer of facial recognition technology himself, worked with the FBI on some facial recognition algorithms years back. A number of legal experts, experts on privacy law, folks from places like the Mass Bar Association, the Committee for Public Counsel Services, the ACLU, I was on it, the NAACP had someone on it. Law enforcement was pretty well represented with somebody representing the DAs, Chief Brooks, as you'll hear, the state police, EOPS, the Executive Office of Public Safety, and some folks from other areas of government as well. In any event, the commission met for about a year. It was a really serious commission. Those of you who are familiar with Massachusetts legislative politics might know that sometimes lawmakers on the Hill will pass a commission bill, a study bill, simply because they don't want to do something to kind of make advocates go away. And this was not one of those commissions. This was a really serious, deliberative effort. Most of the people who were commissioners showed up to most of the meetings. There were really lively conversations. There was quite a bit of fact-finding. The Registry of Motor Vehicles presented to the group on how facial recognition has been used by the RMV for many years. The state police presented on how they use facial recognition technology. The chairs of the commission sent out a survey to law enforcement across the state so that they could inform the commission's work and tell us, how, if at all, they had been using facial recognition technology. We looked at other states and political jurisdictions and what kinds of regulations they were proposing or had enacted, and came up with a set of recommendations that, in my view, is a really historic achievement. At the ACLU, we have a pretty different view of things than folks in law enforcement. Our job is to protect people's civil rights and civil liberties. Their job is to solve crimes. And, sometimes those two perspectives can run into quite a bit of conflict. One of the things that I was really proud of, and think Massachusetts ought to be really proud of in terms of the commission's work, is that, we at the ACLU came into the commission really preferring even more, restrictive, a more restrictive approach, a more limited approach to law enforcement use of technology because of, many of the reasons we'll probably get into: racial bias, the potential of facial surveillance to really supercharge discrimination. And as Woody Hartzog, a law professor at BU, has written in an article, because of the inherent nature of the technology, the way that it can facilitate mass surveillance, centralized control, is a sort of perfect tool of authoritarianism, as he called it. The many threats to privacy and civil rights and civil liberties it poses, the difficulties of creating an appropriate regulatory system with all the checks and balances and accountability and oversight that would be necessary to ensure that the system is not abused, misused. All of that kind of led us in the direction of thinking, maybe we just ought to ban this technology entirely. And of course, the police had a very different view. We want to use it for all sorts of stuff, et cetera. And I think, the commission's work and the recommendations that the commission came out with, I really think represent the best of democracy, because they, brought those two views and a number of other views together, and really worked to hash out a compromise. At the ACLU, we didn't get everything we wanted in the commission recommendations. I think it's safe to say that the law enforcement side didn't get everything that they wanted. But as some folks on the Hill have said, you know, that's kind of when you know that you landed in the right place, is when nobody's perfectly happy with the outcome. So I think that the commission's recommendations represent a true achievement and really strike a pretty appropriate balance between law enforcement's need to use, you know, modern technology, things like facial recognition in rare circumstances subject to significant democratic controls and checks and balances, and the privacy and civil liberties and, you know, freedom of expression and racial justice concerns on the other side, you know, addressed by those very checks and balances. So happy to talk more about it. I'll just leave it at that for now. Thanks, folks.
Thank you very much, Kade, and next we will go to Chief Brooks.
Thank you for having me. This is much like a police training environment, no issues in the front. So I'm kind of used to this environment. Kate talked a little bit about the question. Let me go. So let me back up to the Police Reform Act, which passed by the legislature. It had a piece in it on facial recognition, and Kate has mentioned that. When the bill originally went to Governor Baker, I think that it more closely aligned with some of the recommendations that came from the commission that I objected to. That if I remember correctly, anyway, this goes back now a few years, but I think the requirement was to use the search warrant and that sort of thing. He amended a few parts of the police reform bill, and that was one of them. So the way the police reform bill reads now, the way the chapter reads now, is that the police can use facial recognition in connection with the criminal investigation, so long as they obtain a court order. So you know, I've been on the job a long time, as you heard from my introduction. Sometimes the stuff gets passed, I kind of visualize. So now what? Right, the governor signed off. Police have to get a court order. How do you get a court order? How does that work? You know, so I got in touch with the court system. You guys know about this? Have you heard about this? How do we go about this? So we put together a little working group kind of online to talk about how do these court orders work. Does the office have to appear in the presence of the magistrate? Well, the legislature wanted them to do that. They know how to do that. It's the search warrant statute. This statute didn't say that. So, you know, we could send in a, you know, send in an electronic request for court order, that sort of thing. So just kind of working out the logistics on how this would exactly work. Court system came up with a very nice fillable PDF court order application. I sent a letter to all of the chiefs of Massachusetts. I went served as the president of the Chiefs Association. And, you know, so, you know, I had some ability to reach out to chiefs. A lot of chiefs don't know because it just doesn't take around a long time. So we kind of covered all this. And then when the commission was being named, I was asked to sit on the commission. Everything we told you is true. Commission meetings were attended, although for the most part virtually. There was robust discussion. There were guest speakers that came on, and that sort of thing. And I think what work is not, in this case, not everyone's happy. I think that, you know, some folks wish that there was the recommendations were more restrictive. I really just objected to a few. And as a result, I did not sign off on the report. Which I think upset a few of the folks running the show, but in case that's kind of democracy, that's how the way it works. One of the recommendations is that the police cannot use facial recognition without a search warrant signed by a judge. Because, you know, you guys all lawsuits, so you know what a search warrant is, right? Probable cause to believe that evidence of the crime will be in the place to be searched. This really doesn't fit that. I don't have probable cause to believe that is evidence of the crime, for instance, in the photo gallery maintained by the registry of photographs. You wouldn't know that ahead of time. You wouldn't have probable cause to believe that was true. So I didn't think the search warrant was a good fit, number one. Number two, I thought it being more of an obstacle that didn't really accomplish much. And then second, then it would have to be signed by a judge. Well, in Massachusetts, you only need a judge on a search warrant if it's a wiretap or if you're going to search somebody's body cavity. This is like not that, not even close to that. This involves taking a film photo, which in many cases is a photograph of a person committing a crime. And the more dead on they are in the photograph, the better. The better the lighting is, the better. And then running that photograph against the gallery. And I just didn't think that that was something we should go find a judge to say, Your Honor, the guy holding the gun, we think it's a bank robber, but the gun is straight against the gallery. I mean, I just didn't think that that was realistic, and said so, and as a result, and there seemed to be there really wasn't much space for dissent in all of this. For the members of the commission didn't sign off. So folks aren't happy about that, but I guess that, it is what it is. So that's kind of how I arrived on the commission, seeing the way the statute was written first. And then doing some work around the floor vote issue. And I used what I learned on the commission to apply it in that way. And then I ended up on the commission, as I said. So here in Massachusetts, we have to do a statute. Where the statute reads now is that we can only consult the photo gallery maintained by the FBI, which nobody knew how that worked either. You have to talk to the FBI, so how do we do that? Well, you have to contact the local field office. They have to open a case so that they can run a probe photo. That doesn't seem to make an awful lot of sense. You need an FBI open investigation in order to be able to run a photo against the photo gallery. The only other database we can check is the one, produced by the registry of motor vehicles, and going through the state police. I think it's fine to go through the state police because they've got a lot of people that this is all they do. And they're incredibly knowledgeable, and they know their way around facial recognition, and they're very careful. I know that by having talked to them. But think about this for a minute. We're right on in Norwood, right on Route 95, very close to Rhode Island. What if we have a getaway vehicle that's got Rhode Island plates? I can't run my photo against people from Rhode Island. I can only run against people from Massachusetts. What sense does that make? But you get a lead in some other way that there's a crew. We have we're going through a thing lately where these crews come up from the New York, New Jersey area. They steal checks out of mailboxes. Maybe you've seen this on the news. They actually fish for them. They take soda bottles and wrap fly paper around them, and they fish mailboxes. And they take out envelopes with checks. They wash the ink off the checks. They put their own names on it, or actually usually the name of some intermediary. So they get to actually go in the bank and cash the check. But we know these people are from New York and New Jersey. But we can't check the facial recognition in New York and New Jersey because the statute says Massachusetts only. I'm just not sure who that protects or how. So anyway, we're stuck with the statute. It is what it is. Anyway, that's my exposure. I know that. So how much of this stuff is actually used? The state police in a given week are handed over by the registry about 70 cases where somebody gets a document, an ID, driver's license, that sort of thing, who's already in the system under a different identity. That was about 70 times a week. Police use of it by introducing a probe for somebody committing a crime, and talking to the state police. I know that since October, there's only been 15 of those cases, with only 3 that didn't generated valid leads that the police could investigate. And that's the last thing I want to mention. I'll turn it over. Facial recognition for us is merely a lead. It's simply like getting that I mentioned this in the commission meetings. You're kind of working in the morning and the light's blinking on the tip phone. You play the recording back and it says, I saw the photo in the news. You know what you want to look like? You want to look at, Joey Adams from Lemonster. He's done this kind of crime, but it's just like that photo. Oh, gee, we should go look at him. Does he drive that kind of car? Where was he on that date? What do we know about him? Should we roll up and question him? Maybe should we do a photo array? All of these things. Facial recognition is just like that. It's just a lead. And so the other thing that I'll mention is that one of the other things I was involved in, I talked to the general counsel for the Massachusetts Police Association. We wrote a model policy that parallels exactly what's in the statute. And then that model policy was distributed to every police chief in Massachusetts. And the big letter is running through the policy. It says that, the results of facial recognition constitute only lead and not evidence and are not relied upon for arrest, search, or detention or anything like that. So those are my thoughts.
Okay, Justice Cypher.
Thank you. It's very interesting hearing about the development. Very interesting hearing about the working group and how you and Kade from the ACLU work together and it's always something we hope for at the court, that there will be something coming from another branch of government than just us. So my name is Elspeth Cypher. I am very recently retired from the Supreme Judicial Court. I'm only now getting used to having some freedom of speech. So if I seem a little like a gunshot, you know, I'm still testing the boundary. And I have to say though, I didn't go directly from being a prosecutor to the Supreme Judicial Court. I did spend 17 years at the appeals court, the intermediate court first. And you know, which handles most of the appellate work for the state. And as we would say, you know, the Supreme Judicial Court could come and pluck the good cases away. So now then I had a chance to do that, and that was fun. But I do want to say, this issue, I think, is already running away from everybody. Notwithstanding the great work that's been done in Massachusetts. Every time we have had a case involving a new digital technique, new way to get evidence. There was never a piece of legislation that said, okay, when you get the GPS, when you get the cell site location information, when you look for this, you look for that, here's what you should do, here's what should be considered. So we were usually always just taking whatever the US Supreme Court had said, such as in Carpenter, which gives us the mosaic theory, and framing it against our Article 14 case law, which is very much more protective than the Fourth Amendment, and saying, you know, how do we strike a balance? Because really, we recognize the need of law enforcement, and in particular, not just law enforcement to catch a criminal, but law enforcement to protect and help victims. Because they are often the forgotten group in some of this, or missing people. And so how do we strike the balance between that and between the privacy interests and the civil liberties interests and the equity interests, of which we personally were all terrified too. So it's like, okay, we've got to strike this balance. And I think the closest we came to doing something that's a little bit similar to the statute, and I'm not sure which your statute might have, the statute may very well have influenced this. This was a 2021 case, Commonwealth versus Yusuf, in which the police responded to a domestic violence incident, where there's a lot of yelling and screaming, and an officer goes in wearing his body-worn camera, and he has it on the entire time, as it is per policy, and it's appropriate and all of that. But visible in the camera, you know, he sees that, you know, shows the house, shows some of the inside of the furniture, the furnishings. So after the incident, he writes up his report and he turns in his video cam or his body cam material, and one of the officers saves it. And at that point, we didn't know. Do you save all of them? Is this a practice? How long do you save? What do you do with them? So we really didn't have any information on that. But what had happened with it is that the gang unit was working on another case and recognized, was looking at the video, and we don't know why. Did somebody point him in that direction? Was it just let's look at everything we have? And saw that the curtains in the domestic violence living room were identical to social media that the officers had found. They were working on some case. They had been following some social media accounts, all perfectly legitimate for them to do. They weren't violating anything, and they recognized the inside of the house and the curtains in particular because they were very unique. And so, using that, they were then able to get a search warrant for the home, and they go in and they retrieve the guns, the drugs, and the money or whatever else was there, and an arrest is made. And then Yusuf, the man, was arrested to go to the appeals court, and they say, no, this is fine. But we thought, well, no, this isn't quite fine. So we reviewed it and concluded that what they needed, that, because we're realizing this is gonna create these body worn cameras, they're going to create a database. If the police have the resources, which they don't, but if they did, you could create a huge database of just the body worn material, and there would be software at some point that could search it. So what could we do about that in the absence of much guidance from the legislature? And so what the court ended up doing is we concluded, okay, you can use it, but you have to have a search warrant to use it. You have to have probable cause to access this body worn camera. I'm not sure that's the right answer, in terms of the level of proof that was necessary to look at the police department's own records. I know they're not faces, but curtains or something. They solved a lot of cases by looking at child's sexual abuse material, particularly by looking at rooms and being able to match them to something else. So I don't know if we got it completely right in that case, but we're trying to balance the need of the police department as well as the need of the citizens in Massachusetts, the residents, to have privacy and protections. What I think is interesting, and I'd be interested in the chief's take on this later when we move to more open discussion, is as I was reading the statute that the commission had inspired the legislature to pass. And I guess I'm naive in that. I mean, I know we have a ton of commissions in Massachusetts, 10 committees, and the SJC is guilty of creating them also. And it's a good way to get information, but sometimes I wonder, why isn't the legislature doing it? And why aren't they having public hearings on these issues? Because we're really talking about really significant issues that are going to affect everyone in the future, now and in the future. So I like the idea of getting the working group together and getting the interested parties together to discuss it. And I think it's fair enough that people come out with different views, and some people don't sign on and some people do. But as I was reading the statute, I was thinking, well, okay. It says law enforcement can use facial recognition to execute an order issued by a court or justice authorized to issue warrants in criminal cases, based upon specific and articulable facts and reasonable inferences therefrom that provide reasonable grounds to believe. I got stuck there, I said reasonable grounds to believe. Is that probable cause or is that reasonable suspicion? I'm leaning more to a reasonable suspicion, particularly when I read the next sentence, the next part of the sentence. It said, reasonable grounds to believe that the information sought would be relevant and material to an ongoing criminal investigation. Or to mitigate substantial risk of harm to another individual or group, or without an order to identify a deceased person or persons, and that is very important. I don't know if you recently it was revealed that in the terrible war that's going on, the Israeli government used facial recognition to identify the victims, because they had no way to know who had gone into that concert. It wasn't like they had to register or anything. It was in a remote location. So in those kinds of situations, when you're trying to identify people who have come to harm or deceased people, there's so many missing people every year in just the United States, and that a lot of citizens have taken it upon themselves to sort of run their own databases to collect those photos of who's missing and see if they can help. And that's fine with the private citizens when they do that. So I think those are good. That's a good thing that came out of that. And it also has an exclusion in here that if law enforcement reasonably believes that an emergency involving substantial risk of harm to an individual or group, then they can ask for that order. So there's some guidance in there, there's some reasons in there, there's some specific uses. And then the statute just wants a lot of documentation, as far as I can tell. Why are you doing it? Who are you? When are you doing it? What? So why, when, what? All the basic journalism questions, right?
Right.
And as I said, so, as it's been remarked by Kade, there are some bans in municipal areas. And so that's, I think, at least that's something in Massachusetts, and that will, and there's a bill pending, it didn't get, nobody did anything about it last year. But there's a bill pending to make some amendments to that, I forget what was in that, but it might have tightened things up a little even more. So I'm not disturbed by Massachusetts using it in law enforcement with these kinds of guide recommendations. It is, I kept asking myself, how come the state police get to do it without an order? And the municipality police don't. But I understand there's a need to have it all centralized, one person controlling everything, or one unit, or one agency, so it goes, so that's how it ends up. What came out, there's two other things I just want to mention briefly. And that is that just in January, the National Academy for Sciences included science, health and law technology, issued a report just in January on their recommendations for how to handle facial recognition. And they in fact have a lot of, the one thing I'm gonna just take away from it and super simplify it. Very concerned about privacy, very concerned about what they call false positives, where somebody is misidentified. And that usually the culprit is going to be the algorithm, which has usually been trained on white people, and usually they're going to miss and make mistakes on, and I thought this is interesting, women, Africans, and African Americans. These are not people who were included in the data sets when the algorithms were being created. So basically, the National Academy of Sciences says we need standards, we need research, we need training, we need documentation, you have to do more. And they have a lot of recommendations in there that are way too detailed to go into. But they did spend a lot of time on it and came up with a lot. But one place I got hung up on, and this might just be because I just read a book, I had to look up the title just a minute ago. In preparation for this, it's called Your Faces Belong to Us by Kashmir Hill. And that book is really very interesting. It's and this is one of the National Academy of Sciences did get to this, private actors. And Your Face Belongs to Us is about the corporate world or people creating an app that starts facial recognition, and they put it out there and sell it, and we just don't know the scope to which private corporations are doing it. Can you walk into a store and they know who you are? You know, if your Facebook page shows you went in, somebody else knows too. So I feel good about government, not having just because I worked in it, but because Kade works with it, with the chief. And there's a concern in Massachusetts, we're alert to it, but I'm a little worried about the private sector. Because I don't see too much coming out of that, and I don't, the National Academy of Sciences, all these great recommendations with the federal government should do this, you should that. When are they gonna do that? I mean, I don't know if they're really gonna get off the ground and do that, or Congress will. So that's basically what I would think about.
All right, and I do want to return to the private sector use of that at one point, but I want to sort of as a jump off point to our discussion, I was gonna open it, just asking you all what aspects that you thought in this report were really good, what were more problematic. I know the chief and Kade already hinted on that a little bit, but it sounds like all three of you are sort of centering in on the standard. That is the issue. You have, the probable cause standard, you have reasonable suspicion, you have the standards that already exist. So I'm gonna sort of alter that question a little bit and say not just what you think about the standards in these recommendations, but is there a need for a new standard when it comes to facial recognition?
You know, that's a very good question. I don't know, you wanna take that first?
Oh, thanks. I'm not, there certainly should be standards, I'm not sure. I'm not sure that this is as easy to quantify as people might think. So the whole issue of the state police doing this.
I think I can turn it down.
See, technology is problematic, see, that's what we're saying.
Thanks. The whole issue of the state police doing this, and I would not be, nobody would want to say, look, only the state police can do this stuff. But to funnel this kind of work through a unit that really does this and is well trained and knows a little bit about it, and knows an awful lot about it. And in talking to these folks, which I have on this topic, probably in preparation for today, it's not so much the score that they get back. A lot of it is, hey, this is the probe photo, and this is what the system generated. Number one is, does that really look like the guy? Number one. Number two, let's look into his past. Let's look into his record. Let's look into where he is. Let's look into his vehicle. I mean, they do all of this between getting some sort of a result and even approaching the suspect. And sometimes simply take a pass to say, we're not seeing enough good information here. We're not even going to get on that road. And that's difficult to qualify. And some of it really does come down to funneling this information through somebody who knows what they're doing, who's trained, and who's careful about this. In the model policy, it calls for one person on each police department to the conduit for these requests. So if a detective on my agency wants to run facial recognition, they have to go to the detective sergeant. He's the one that makes the call. Is this probe photo even good enough to be used? And then he's the one that contacts the state police, walks them through the court order, issue order. That's really easy to do. Fields the information that comes back. And then where it's going to is going to a state police unit that really, this is all they do, right? They work with these databases and they work on facial recognition. So, there should be standards, but they're not always going to be quantifiable standards. Sometimes it's going to be procedural standards. And Massachusetts, I'm actually pleased with some of these outcomes in some of these other areas. I did a lot of work as I read the introduction and eyewitness identification. And if you look, I think it's still there. Like Massachusetts, I think is the only state where the Innocence Project considers it to be a state in full reform, driven by the police, right? Not by legislation, not by case law, but because get together, drafted a model policy, drafted training, and talked to the MPTC, and MPTC mandated that as an in-service course for every cop in the state, and mandated it with the law of construction and the academy. And so going forward, everybody receives that same level of knowledge. So it's not always easy to quantify, but it is easy to do procedurally.
Kade, what do you think about the standards?
Yeah, I mean, the standard question, I think, I understand why Chief Brooks has a different view of the warrant requirement. From our perspective, so there are two kind of separate proposals. Well, one of them is actually the law. The current law, as Justice Cypher said, requires police, including the state police, to get a court order to perform a facial recognition search. And the court order can be obtained after demonstrating that the search is relevant and material to an ongoing criminal investigation. So relevance and materiality, as you probably know, is a quite low legal standard. That means that you don't even necessarily have to be suspected of a crime to be subjected to one of these searches. You could be a witness. You could be, someone who law enforcement wants to interview about a crime. That's concerning to us because it's such a low standard that really anyone who's tangentially related to a criminal investigation could be subjected to one of these searches under the current statute. Our preference and what the commission recommended the legislature reform the law to require is a demonstration of probable cause. And I think that makes sense because the scenarios in which we're imagining law enforcement will use facial recognition to advance serious criminal investigations are cases in which someone has been photographed either during the commission of a crime or, immediately after or before the commission of a crime. So a few examples include, I think probably the obvious one is the Boston Marathon bombing, right? The investigators who poured through all of that video came upon the images of who we later learned were the Tsarnaev brothers placing those backpacks down, at the scene of those two explosions and then walking away. Once they got a clear image of those guys' faces, they could go to a judge, for example, under the recommendations. If that were the statute, they could go to a judge with that image and say, Your Honor, we have probable cause to believe that these men who are currently unknown to us placed these backpacks down at the site of the bombings and walked away. We therefore have probable cause to believe that they placed the bombs. We need to run a facial recognition search to try to determine the identities of these unknown men. So that's one obvious example. There are others. If someone is captured on a surveillance camera grabbing a child and ferreting them away, if you can get from the video a clean still of the image of that person's face, you can go to a judge and say, Your Honor, we have a video showing this man kidnapping a child. That video is the probable cause that we need to show you that we believe this person is responsible for the kidnapping. However, we don't know his name. We'd like to run a facial recognition search to try to identify this person. Bank robberies and other examples of cases where someone is likely to be photographed during the commission of a serious crime. So, that's the standard that we think is the most appropriate. The probable cause warrant is the gold standard of American justice. It's what the framers established in the Constitution. It's what, for those of you who know your Massachusetts constitutional history, John Adams established in writing Article 14 of the Massachusetts Constitution. And we think it's appropriate for this level of intrusion. Facial recognition is a particularly powerful tool because it enables government officials, or as we'll get into, I think later on, people in the private sector as well, but for now, let's just talk about the government, to identify someone at a distance, maybe even retrospectively, without that person's knowledge or consent anywhere in the world that they go. And so for that reason, it's a pretty profound privacy intrusion. You can imagine, for example, the danger of an authoritarian government possessing this kind of technology. For example, the Putin regime in Russia using facial recognition technology to track and monitor dissidents, to identify people at protests. It would be trivial using facial recognition technology, for example, for members of an authoritarian regime to fly a drone over a protest and capture images of everyone there, and then run those images against a facial recognition database to essentially download a list of people they suspect of being subversives or anti-regime dissidents. So that kind of power ought to be constrained using the existing tools that we have in a democracy. And it's our view, and it was the view of the majority of the members of the commission, that the warrant standard is appropriate for that level of intrusion.
Justice, you have some thoughts about the standards?
Well, sure. One of the thinking about standards, there is the legal standard, and distinguishing between reasonable suspicion and probable cause. I'm going to go back to the statute and read the language, and then I'm going to think, what are you using it for? Is it to prove a crime? Are you looking for probable cause a crime has been committed, or are you looking for a reasonable ground to believe information might be material and relevant to your investigation? They seem somewhat different. So the legal standards are one thing, and certainly the legislature and the working groups and the courts will continue to refine those. And maybe there should be a different level for some kinds of information. Different, maybe it should rise to, I think we have pretty strict requirements on body cavity searches, a little bit higher than everything else. Should it be higher or should it be as easy as a Terry stop? So there's still, I think there's still room for discussion in that. The thing about, and so procedural standards is, the chief was referring to, how do you get it, where do you put it, the who, what, where, when, and why, what do you need it for, making sure that there's a process, it's filtering through the state police, and I'm glad you pointed out the state police have to get an order too, so I was wondering about that. But then what you need is you need standards, algorithm standards, and that was what the National Academy of Sciences was very focused on in January when they released their report. These algorithm standards, we need more testing, you need better databases, you need to get the bias out of the algorithm. And so they've made a lot of recommendations on that. So there are different levels of standards. We're talking different kinds of standards we're discussing, and they all come into play. But I think my takeaway from everything has been standards, whether they're legal, procedural, technical, scientific, training, whatever it is, plus training. And policy, if, you know, so many places probably don't have any policies on how it's going to be used. Other states, I think we're fortunate that the group did the job they did, so that we are a bit ahead of the game. Even though I think we're all way behind when we get to the commercial sector. So the standards, you know, they'll be in process, but they did recommend very strenuous standards for the algorithms to make sure they can get address issues of equity and racial disparity.
Yeah, you anticipated my next question because technology is only as good as its own reliability. And I talked a lot on Monday about the problems when it comes particularly to race and gender and difficulty identifying the accuracy rates with white men are really high. But often the accuracy rates drop when it's women, when it's LGBTQ folks, when it's people of color. And so how do you get to that though, Chief, when you have, you know, you're at the local level or at the state level, but these algorithms are being created by software companies. How do you get at ensuring that this data is accurate? And one idea that I had is making it a requirement before you any location, any government procures this technology, that the creator of it, that the developers of it have done sufficient testing. But how does that work in this mix?
So I think there's two issues on the racial disparity front. One, as the judge pointed out, is that the algorithms were trained using a higher percentage of white males than black males and a higher percentage of males than females, which then tilts the algorithm in the direction of higher accuracy in the group most populated in the training of the algorithm. So one of the ways to do that, I think I know you've seen the companies do that, and a few of the companies I've looked up have shown increases in their accuracy even over just over the last few years, is to do more training of the algorithms around those groups that we just mentioned. And then I think that there's also an inherent problem that is something that police have to be wary of, and that we have to think about, is that, again, only just from what I've read, is that darker skinned faces yield less contrast, and as a result, some of the systems can struggle more with that. So, you know, it's something to, if you're using facial recognition in a criminal investigation, you have to be aware of all of that. Now, the system used by Massachusetts is Idemia, and that's a company that they make our electronic fingerprint machine. They are the company that produces Massachusetts driver's licenses, and then they also have facial recognition that runs against that gallery. And they update that system on a regular basis, you know, improving it as they go. Because there's been a lot written about this, and this is one of the problems that, quite frankly, governments, state governments essentially, that are buying this kind of, that are engaging in contracts with companies like AWS, which I think is the largest in the country, are saying, hey, look, you got to bring your game up, so I know that some of those improvements have been underway. But it does all, and I don't want to simplify it, but it does all circle back to, that you can get and again, the state police have said, we really don't pay too much attention to the numbers. It's got to come down to, we generated a suspect. Facial recognition isn't evidence. Nobody rolls a machine into the court and says, and turns it to the jury and says, watch this. It's not that. It's the call on the tip line. You ought to be looking at this guy. And facial recognition is the same thing. You ought to be looking at this guy. And then it really comes down to all of the other investigative avenues that the police pursue in order to figure out, is this the guy who robbed the bank or is he not? And I think that so from our end, some of the ways that I'm familiar with are the ways that my department has used it. And again, talking to the state police, they just heard the story where a guy had a medical episode, went unconscious, had no identification on him. They got him to the hospital. When the doctors removed his clothing, the surgical scars were on his chest, alarmed them, and they said, we really can't work this guy without knowing like what's underneath those scars, exactly what's been done. Police came in, took a photograph, sent it to the state police, ran it against the gallery, facial recognition, identified the patient, contacted his family, that sort of thing. So kind of the community caretaking and the emergency that's envisioned by the statute. We had one where we again, one of these somebody involved in theft $96,000, if I'm not mistaken. We identified a suspect in the theft. He claimed to have been sent there by another bad actor that had engaged his services, didn't know his name, didn't have contact for him. I think only knew a first name, but he said, I do have a Snapchat photo on my phone. We used that, ran against facial recognition, identified the subject who was actually running the game, who would put this guy up to it. All sorts of a lot of frauds and a lot of thefts.
So I want to give Kade a chance to talk about the accuracy, the reliability of this, and also move it forward to the next part that is a concern for me is, unlike fingerprints and DNA, which you go through the standard, or whether it's a warrant or something else before you get it, everybody can see your face. You can get the information first and then decide the standards later. So both because of accuracy and the ubiquity, we can't hide all of our faces, Kade. Talk a little bit about that.
Yeah, so on the accuracy question, there are hundreds, if not thousands, of different companies that market facial recognition algorithms of varying reliability and accuracy with different bias rates for different groups. So no two facial recognition products are equal. It's like, how one pair of sneakers differs from another, right? They're just different products. And on the commission, we didn't want to get too in the weeds on legislating what algorithms police ought to use for a couple of reasons. One is that I actually think that the accuracy ratings, quote unquote, are pretty misleading because the tests that the National Institute for Standards and Technology, they run something called the facial recognition vendor test. And those tests are performed under pristine lab conditions. So another way of saying that is they run those algorithms using essentially perfect images of people from the front, well lit, using high definition cameras, and compare those perfect images to other perfect images. Now, Chief Brooks knows, and probably anybody who's ever seen a CSI show knows, that in real life it doesn't work like that. You have a grainy image of someone from the side at an angle. You have shadows, obscuring their face. You have a photo. You have somebody with a baseball cap with half of their face obscured. You have somebody wearing sunglasses, right? And as Chief Brooks said, we know that it's not just the facial recognition algorithm that may have racial bias. those of you who are familiar with the history of photography will also know that cameras have been designed for a long time to take more beautiful photographs of people with lighter skin than people with darker skin, which is why if you look at old photographs of your Black friends and family, they look really bad. You know, and it's even the case with newer digital technologies that, you know, not all cameras take photographs of people of color very well. So it's actually the raw material that's being fed into the facial recognition system that has sometimes a bias in it as well. So anyway, you know, you probably heard the phrase junk in, junk out. If you're putting junky images into a facial recognition system, either because they're from a weird angle or there are shadows or odd, you know, portions of light, or somebody's face is partially occluded or it's at a strange angle, and then you're comparing those images to a driver's license image, right, which is a perfect image, it's not necessarily going to give you a good result, even if the facial recognition algorithm is quite advanced comparatively to others. So because of those problems, you know, there, as far as I know, there has been no national standardized test of facial recognition algorithms using these real life images. They use ID style images. So I wouldn't necessarily rely on those studies as a measure of the performance of these systems in the real world. Because of that, we on the commission thought we shouldn't be telling in statute, you know, government agencies, you have to use a system that gets an A+ on one of these tests, which is kind of the wrong test anyway. We thought the better way to go about it would be to designate the Executive Office of Technology Services with the authority to authorize the police, the state police, to use facial recognition systems that have been vetted by EOTS. And I think that that's a pretty good way of going about it. As Chief Brooks said, the system that the state police currently uses, created by this French multinational defense company called IDEMIA, consistently ranks at the top of the NIST testing in terms of its accuracy. Again, there are problems with those tests, but insofar as that's the test that, you know, we use, that system ranks pretty well. So we weren't altogether too concerned about the existing system that the police are using. It performs pretty well compared to others. Going forward, we thought, you know, if the police want to use a different facial recognition algorithm, they need to go to EOTS. EOTS needs to do its own, you know, investigation of those tools. And then there ought to be a public hearing so that people like me and folks like Dr. Eric Learned Miller, people who are real experts in the development and application of facial recognition technologies, can provide expert advice to the state government, that there ought to be a process like that instead of something in statute that says, you know, the system has to have a 92 percentile accuracy rate or something like that. So that's my view on the accuracy questions. I also think, you know, to Chief Brooks's point, the real, you know, bread and butter of how this technology will actually implicate people's rights, how it will impact their day-to-day experience, is going to be borne out through procedure, right? Through policy and procedure, and how the police actually make use of the technology. So we've seen in a number of cases nationwide, not in Massachusetts, thank goodness, I think in part because of the collective work that we've all been doing to raise the standards on the use of facial recognition technology here, but in other places, in Detroit, for example, the ACLU has a client, Mr. Robert Williams. He testified before the commission actually at our public hearing, who was wrongfully arrested. He's a Black man. He was wrongfully arrested by the Detroit police because the exact scenario that Chief Brooks described should not happen is what happened there. The police did a facial recognition search of a suspect from a crappy image from a store surveillance camera. This guy was suspected of stealing a couple watches from a watch store in Detroit. They looked at the picture. They said, we got the result of Robert Williams from facial recognition search. They said, okay, sure, go pick him up, right? So they arrested him on the basis of this alone. That is terrible police work. That is the kind of thing that we are, you know, trying to make sure never happens in Massachusetts. And, you know, was the algorithm at fault? Partially, but so often it's the case that when there is high stakes technology and then a high stakes, you know, criminal investigation related to that technology, it is human error as much as it is error in the system that leads to those negative outcomes. So, you know, it's really crucial that we do everything that we can to build the systems, the policies, the procedures, you know, the relationships. And it's really heartening to hear that Chief Brooks has been continuing to work so hard on this issue to ensure that we build a foundation in Massachusetts of knowledge and knowledge sharing and systems and support so that those types of things never, ever happen here in Massachusetts. And I forget your second question, I'm sorry.
No, it's okay, because I get to the private sector concerns that we sort of hinted at earlier, and then save enough time for people to ask questions. So I will ask it again, interspersed with the questions that we have below, but I want to get to the private sector. We were talking about government intervention, what they can do. I told an anecdote on Monday that I saw that Rite Aid agreed to stop using facial recognition in its stores. I thought, yay, good for Rite Aid, what a great proactive step, until I looked further into it and found that the FTC strongly encouraged Rite Aid to stop using facial recognition because they had been found to violate policies associated with it. So that again is government intervention in that, but private collectors and aggregators of this information are everywhere. They're in stores, they are, you know, in your video doorbell, they are everywhere. How do you deal with that in the setting? Because that can ultimately, and has often been given to law enforcement and used as a basis for this.
First of all, really curious, what was Rite Aid using facial recognition for? Do you know?
I assume maybe for evidence in shoplifting case, I don't know.
I think it was that they had a list of people they suspected of shoplifting and they wanted to keep them out of the store.
Sometimes people just become so overwhelmed that technology is cool, they just can't wait to try it on something, and sometimes when they try it on, it doesn't make any sense at all. Anyway, that's just, and you told a story about Madison Square Garden. On the side of the plaintiff's here, I think that's outrageous, to be honest with you. You know, it's a, I have friends who are attorneys, I could admit that, right? I just think that's outrageous. They're a private entity, so at some point in time, somebody have to step in and prohibit what they're doing, but, yeah, you know, it's, obviously, you know, from my end, you know, we don't deal much, in that venue. The only way we deal with private companies is that we have a lot of shopliftings at Home Depot. Like, we have more theft at Home Depot, like, than all of our other sites combined, I think. It's just all, and it must go into what you're paying when you shop at Home Depot. But anyway, that's just us, you know, going there for these surveillance photos. And we get, I was involved with the creation of this website called massmostwanted.org, where police departments can upload photographs of unidentified subjects, and you can kind of click on the case and send in a tip. And I think we score much better with that than we do with any kind of facial recognition on people stealing from Home Depot, but we don't get, police really just don't get involved too much on the private side. I have not run into this where somebody says, hey, our system is detecting such and such a person, and no police actions needed. We just don't see it.
Justice Cypher, what do you think about the standards that are required? Because often these private companies would give information to governments or police departments without anything, just when they were asked.
Right, and that raises a point I did want to make. I appreciate that question. One point before I get to that point, was that in terms of procedure and error and making it all work, one thing that I think the commission recommended, and also the National Academy for Science came out and said, you've got to have a human being in the loop. You cannot just let the machines work their magic. So when the match is made, some human being has got to double check and really look at it and make sure they are good photos and they are actually a match. But with regard to the private industry, I think at this point we can say that Apple and Google, for the most part, are setting our federal standards for whether they're for search and seizure of data from their systems. And I say that because they used to just give it to the police, and then as things grow, then they wanted a subpoena, and that now they're requiring search warrants. And I think Google has said, I don't know if they said we're never going to give you this is what they did. you've heard geofences where you can get all the phone numbers of everybody who was in a certain location at a certain time, and then through filtering mechanisms, finally maybe get it down to a suspect. They said, well, we're not gonna do that anymore because we're gonna keep all that geolocation data just on your phone. So it's not in Google's system. So they are doing their own things. And those things that they're doing are often driven by the worldwide market because they have to handle countries and satisfy countries that do have better privacy controls than we do. So in fact, we are the beneficiary many times of whatever Europe's privacy policy is, or France's privacy, any particular one. What you hope doesn't happen is that you would become the beneficiary of China's policy on this, because that would be rough. Really that's where you don't want things to go. So I think that, but aside from Apple and Google and their data, it's just so much. I mean, your data brokers buy so much data, matching it to your face is their next step, and for whatever reason they'll use it, I don't know, but I think there needs to be regulation in the United States from Congress on that, just so we know what's happening. We don't even know what they're doing.
Yeah, and what Kade thoughts too, but I just wanted to say to your point about human beings, this is a point that I said Monday, so forgive me for those who were here then for the repetition. But it's not just at the, design level that you need. This is a case for DEI. You need people who can recognize it and who can be human beings with decision-making power at the point. It's one thing, I gave an example of being patted down by TSA because of my hair, and that TSA is aware that there is a strong racial bias built into their detection systems. But the people on the ground, the TSA agents there, didn't have the agency to not subject me to a secondary search. They couldn't say, oh, yes, we understand that this happens, and let them go through. You need people of diverse backgrounds. There's a thing called human racial blindness. That people are better able to recognize people and the features of people of their own race than others. It's just a natural way that our brains work. So you need people who have the ability to make different decisions at the point that the humanity hits the technology. But Kate, I want to give you a chance to say something before we go to audience questions.
So we don't have to look to Europe, thankfully, on good consumer privacy law dealing with biometrics. Illinois has the nation's best biometric privacy law. It's called the Biometric Information Privacy Act, and it should be implemented nationwide. And it's very simple and it's very effective. And the tech companies hate it because it's very simple and very effective. It really essentially does one thing. It says that if an entity wants to collect your biometric information, they have to get your affirmative consent. That doesn't mean you click yes to agree to a long terms of service that you didn't read. It's actual meaningful consent that's separate from other terms that says, yes, Apple, you can collect my biometric information. And that's really all we need, because if we had a law like that nationwide or in Massachusetts, it would mean that Rite Aid couldn't use facial recognition when you walk through the door to, scan your face and document what you buy and, put you on a shoplifters list. It would mean that, Madison Square Garden could not do what it was doing without the consent of the people it was doing it to. And it's a very simple and elegant and appropriate solution to the privacy threat posed by corporate biometrics collection. And so we are pushing for a similar statute like that here in Massachusetts. And we believe it ought to be the law of the land across the United States.
Okay, I want to save some time as promised for your questions. There are microphones that will go around, so just wait for the microphone and Kade and Lucy will be looking out for you.
Hello, and thank you to our panelists for joining us. I think my question might be for Justice Cypher, but given that this technology can often inaccurately identify someone as a suspect on the basis of race, do you think that there's a strong equal protection challenge where this results in an arrest?
Do I what about an equal protection challenge? I didn't hear that last part.
But do you think that there's a strong equal
Well,
protection
there's a
challenge?
case going on right now at the Supreme Judicial Court, so I am too new to even to really comment on that. Too new to leave room for the least. But there certainly is an issue there, and they certainly seem to think there is, because they took the case from the appeals court. And so is that Dilworth?
Yeah.
So if I were you, well, I'd keep my eye out for that one in the next couple of months.
Any more questions?
Kate, can I ask you a question?
Of course.
Would Kim reference this in her address on Monday, would our consent to using our face for ID to access our iPhones, would that count as affirmative consent?
Yes.
So those of us who use facial ID to get into our phones, we've basically given away all our privacy.
No, not necessarily, because Apple has a pretty good privacy policy with respect to biometrics. And companies are legally required to adhere to their privacy policies. One of the reasons why we think BIPA is such a good law in Illinois is that it has its own enforcement mechanisms. It allows for individuals to sue to enforce their own rights. In other words, a private right of action. And that is really important because right now in Massachusetts, lacking a BIPA-like statute with a private right of action, the only way to enforce your rights if Apple uses your facial recognition data in a way that contradicts its privacy policy is to sue them under 93A, the Consumer Protection Statute, which basically makes it a civil offense for a company to lie to you about what it's doing with your information. The reason that that's maybe not the best approach is because courts have held that you actually have to be harmed by the use of your information. That, well, it's not totally settled law, but it's not clear whether Massachusetts courts would say that a mere violation of the privacy policy constitutes a harm under 93A that is litigable. And so something like the BIPA statute is preferred because that courts have held in Illinois basically says a violation of your rights under BIPA, if someone collects your biometric data without your consent, that's a harm. You can sue and recover damages for that. So that's really what we need the law to look like everywhere on a range of digital privacy issues. Because if it doesn't, you're not going to see the interest from, the lawyers who file these cases on behalf of people, because they're not going to collect any money if courts don't, acknowledge that the unlawful collection of the information is itself a harm under a consumer protection statute.
So I do have another question as well. I know as part of your work at ACLU, Kade, that led to a lot of municipalities to voluntarily ban the use of FRT by law enforcement. I believe Somerville was the first and the second in the nation to ban it. I think a lot of people will hear this discussion and say, well, why isn't it just banned? Why isn't that the best thing to do? And you take care of all of it. So I want to get everybody's view on whether or not it should be banned entirely. I'm going to start with Chief Brooks.
No. I think for all the reasons we've discussed, I mean, there have been opportunities, reduced opportunities to use facial recognition to solve crimes. The use is not widespread. This isn't happening every day. There are just very select cases that the probe photo is sufficient to be taken by the state police and run. And most of the time it's run. They do not get a lead out of it. They say, hey, this is not finding anybody. That's the majority of the cases. So I don't think that this is widespread. It's not happening every day. To ban us from being able to use it, I think it's too much. I think it's going over the top.
Yeah. Sorry. Yeah, I just want to get Kate's point of view on that too, and then the next question.
So the national ACLU's position remains that facial recognition ought to be banned in government, period. We at the ACLU of Massachusetts have evolved on this question, in part because of the political reality. You know, it is our view that we shouldn't make the perfect the enemy of the good, and that there's no political appetite for completely banning facial recognition on Beacon Hill. And short of, you know, that political appetite somehow materializing, which I do not think is going to happen, that we ought to have the nation's best standards in place to protect people's civil rights and civil liberties. And so that's what we're working towards.
I just want to say thank you to the panel for joining us.
You might want to stand up so they can see.
I guess given what Chief Brooks was saying about the use of this technology in practice, how he likened it to a tip, and the subsequent investigations that police do, I guess my question is, to what extent does that mitigate our concerns about potential bias against technology?
Just to say, to talk about, you know, I think the term that was used in the National Academy of Sciences report was human in the loop. And they referred to having a human in the loop. You know, I just think that at some point in time, we have to rely on people in government, and particularly in law enforcement, to do the right thing, to be educated, to be trained, and not to react automatically to a particular result, to a particular, you know, Kim talked a little bit about, you know, going to TSA and the person at TSA not having the authority to use better judgment than perhaps buzzing technology and some sort of policy somewhere. And a number of years ago, and I forget what precipitated, but I heard a radio car going off on a call. A resident had called and said, you know, there's a guy walking down my street and I know he's not from the neighborhood, and can somebody check him out? And I knew that the officer, one of my officers, would be completely polite and engaging and say, hey, you know what, hey, you got a call. I said, well, the car broke down and I'm going to work or whatever. All right, well, listen, have a great day. And it would be a very positive experience, but it would be a positive experience that shouldn't happen in the first place. Because a guy who doesn't belong in my neighborhood is not a sufficient reason, even for a consensual encounter. So we have a policy that all suspicious activity calls must be behavior-based. And it is given out by dispatch saying, we got a call about a person who's unfamiliar to the neighborhood. They don't call a sector car, they call a sergeant. Sergeant waves response, and we don't go at all. And you have to, at some point in time, rely on people who have come into government, or come into policing, that don't want to arrest the wrong guy, that understand the limitations of things like facial recognition, for other types of forensic evidence, like hair follicle evidence and forensic oncology and all these other things that have been kind of debunked. And they kind of look through it and really just use their judgment and do their jobs properly and to a higher standard. So that's what I think. That's what I think we keep coming back to. Just as if you got the call on the tip line and said you want to check out this guy, and when you start checking him out, the first 3 or 4 things you look at don't line up, and you walk away, and know that that's not your guy.
Can I just add one
Yes.
thing to that? I think that is a very important point, that as much as we're focusing on this for inculpatory reasons, it's equally as important that this be used to exclude people. And police are certainly doing that in other areas of technology. So to use it to exclude, move this on, this is not who we're looking for.
Time for one last question. Well, then I would just want to say thank you. This issue is so nuanced. There's so much balancing that needs to come into play of privacy and public safety and civil rights. And thank you all for sharing your wisdom and your insights, and for being and doing the work you're doing on behalf of all of us. So